Okay. Well, first, this has been a process for you in terms of defending William Wood, particularly, I guess, maybe take us to last fall when this evaluation was taking place. What was going on and what was the intent as somebody defending this person?
Well, early on, we discovered mitigation information that supported our belief that William Wood suffered from intellectual deficits that would prevent him from being eligible for the death penalty. It required a lot of investigation and review of historical as well as current evaluations, psychological evaluations, school records. So it was a process, and we weren't prepared when the case was initially authorized to present that mitigation evidence because we hadn't been able to gather it. We didn't have enough time to gather it. So it was an ongoing process. When we believed we had enough information to present to the government, we sent it to the U.S. Attorney's Office asking that they join in our request to have them reconsider and deauthorize the case. They weren't prepared to do that unless they had their own evaluator come to the same conclusion. And then it took a while because of the pandemic. Actually, there was a delay as a result of the pandemic. So it kind of delayed the government's ability to conduct the evaluation of William Wood. And that happened in November of 2020. And once we got the results, then the government put that information in front of the Capitol Review section, along with the packet of materials that we sent to the government. And we were notified today that they, in fact, agreed that the case would be deauthorized.
What can you say about the findings of the evaluation?
Well, what was concluded is that he, in fact, did meet the criteria under the DSM, that he did suffer from intellectual deficits. And the Supreme Court has held, as you know, in 2002, that if somebody suffers from and meets the criteria under this Atkins case, that they're not eligible for the death penalty. And in fact, that based on IQ, and they look at the IQ scores in addition to deficits in different domains, social domains, to see whether or not they actually fit the criteria. And in fact, William Wood did.
That's with regard to it being considered cruel and unusual punishment if somebody has those deficits under the Constitution?
Yep, correct? That's correct. That's correct.
But that doesn't mean that his conviction in state court goes away, or that he couldn't be convicted in federal court, at least if a case does proceed. It's not the kind of decision that says somebody's not fit to stand trial.
Correct. That's different. It's not a question of it's not a competency issue. It's not whether or not the individual was insane. It's just a question of their ability to, I guess, conceptualize information, and really what we were able to show is that his intellectual deficits did reveal that his perceptual reasoning skills, the ability to understand, organize, and think with nonverbal information and to solve abstract visual problems were in the lower than 99th percentile of the rest of the population. So that was one thing. His working memory skills, which also included the ability to hold information in his mind long enough to consider it and manipulate it, was lower than 96% of individuals, same-aged peers. So those are the types of criteria that they look to determine whether or not somebody would be eligible for the death penalty. So it's not a question of, knowing right from wrong, or whether the individual was insane at the time that they committed the offense. And as you pointed out, the basis for the Supreme Court's decision is that it's cruel and unusual to execute someone who suffers from those deficits, because they do have below average intelligence in terms of functioning and being able to process and conceptualize information the way the average person would.
But in the case of Mr. Wood, even though you're using the word average there, you're saying this isn't even about average. This is at the very, very bottom of the rest of society in terms of how he performed on these tests.
Correct. He met the threshold criteria that they consider fitting under the DSM, where there's a cutoff, and it's not necessarily a black and white by any means, and it's evolved over time. And in this instance, we were able to show through the testing, and it's historical too. It goes all the way back to when he was very young, when he was tested in school. So it's not that he was just simply evaluated for purposes of presenting it to the government in this case. This was all, although there were more recent tests that were done, it was also historically shown even before his 18th birthday, which is a requirement in order to establish he suffered from intellectual deficits. It had to manifest itself before he was 18, which in this case, we clearly had enough information to suggest that it had.
I noticed in the U.S. Attorney's filing that they mentioned that they had spoken with past counselors and teacher. And did you do the same? And what was the essence of that type of historical finding?
Yeah, well, we interviewed individuals, and we provided names to the government to allow them to go forward and to facilitate their own investigation into his intellectual deficits. And really what you would find out, the theme was very similar, that there were behaviors that were manifesting themselves early on in his childhood, where he was a chronic runaway even as a toddler, and that he could not function in school like the rest of the students. Oftentimes what happens is emotional outbursts are sometimes associated with behavioral disorders or emotional disturbances. And in this case, while that may be so with William, we also uncovered that he had incredible exposure, high exposure to lead paint. So his lead levels when he was 3 years old were really off the charts, and they never really did any remediation as far as trying to, minimize or address the lead exposure that he had. And I think what we've also found is, and research has shown, that individuals that do have exposure to lead to the level that he had, it does impact IQ and intellectual ability. And in addition to that, we also have family historical information that showed that some of his relatives suffered from mild mental retardation. So it goes way back in his family history as well. And we were able to show that information to the government. But really, it was really a sad case when you look back on William Wood's history and what he went through. I mean, really didn't have any friends, was bullied. One of the principals that knew him when he was in grade school discussed how he was probably the most bullied child that she ever witnessed. And it wasn't just, it was pretty consistent throughout many of the individuals that we spoke with, that was in fact the case. So, and his parents weren't in a position to sort of help him with some of these issues. They had their own struggles. So it was, sort of this, I guess, cycle of, it wasn't necessarily a failure on the system, but in some regards, I don't necessarily believe he was properly diagnosed as a child. It's typically he's misbehaving, he's ADHD, let's medicate him. And, there was a lot more to William Wood and what was going on with him than just, hyperactivity and that sort of thing.
But he still takes responsibility, as he did in the guilty plea on the state side, for what those actions. And I mean, 2 people were killed, obviously, and it could have been more. And he still takes responsibility for that.
Oh, absolutely. Yeah. And he, he is remorseful for that, obviously. In hindsight, if he could rewind time, he would want to take that all back, obviously, and understands the pain that he's caused. There's no question about that. And he is doing life without parole, and that will not change. He pled guilty in state court, and he received the sentence and entered the plea. And again, is remorseful for his conduct in this case.
Are
My
you
understanding is that
open to the federal case continuing or not?
my understanding is the government intends to move forward and prosecute the case, notwithstanding the fact that the death notice is being withdrawn. So I don't really understand the reasoning behind that, because he is doing life without parole in state court. So it doesn't seem that there would be any real purpose served in moving forward. But it's my understanding that that's in fact what the government's intention is at this point.
They mentioned in their filing or a guilty plea or plea. Do you anticipate any discussion about a plea, or would you rather go to trial at this point?
Well, certainly that will be a decision that William will have to make after he consults with the defense team in this case. No decision regarding that has been made at this point, so I'm not certain what he'll want to do. But that I guess we'll decide that at a later date. Right now, he's not even aware. We're not even able to communicate with him. So he doesn't even know at this moment that the death notice has been withdrawn.
What's the latest on where he is physically and his challenges to get to a place where he could have regular interaction with his defense?
Right now, he is in the Essex County jail in Elizabeth, New Jersey, which is quite a distance. It's really Newark, New Jersey. It is a distance, and we've had issues with communication. We filed multiple motions and letters trying to get him transferred to a DOCS facility, because we felt that that was the best place for him while this case was pending, because he could start engaging in programs and rehabilitative efforts. Whereas when he's sitting in a county jail, he can't do those things. It's been difficult because particularly with the pandemic, they move him from facility to facility and he's in solitary confinement, whether it's because of COVID or acting out or whatever the case may be. He's frustrated. It does impede our ability to communicate with him. Every facility has different requirements, and we've had to travel great distances to see him and maintain contact with him. And somebody with his intellectual functioning is also difficult for him to understand that, we're not always able to contact him and the reasons why, and there's a level of frustration. So it's been a difficult road, and we were hoping that he could be transferred into DOCS, because I believe if he were, it would be easier for us to communicate with him and speak with him rationally about how to proceed and what he may or may not want to do. But when somebody's frustrated and being moved around and he doesn't know what's happening, we need to reestablish a very good connection and relationship with him. And it's been a struggle. We've given it everything we've had, and we've had, we have a great defense team, and we've all pitched in, and we're all trying to do the best we can, to maintain that relationship. But it has no doubt been very, very difficult.
Mm-hmm. What's the timeline do you expect from the U.S. Attorney to make decisions, or have they given it back to you in terms of this plea idea? Who's making the next call, I guess?
Well, in terms of whether or not the case is going to proceed to trial,
Mm-hmm.
The decision has been made, as far as my understanding, is that
Right.
they are moving forward regardless of whether or not the death penalty is on the table. So that decision apparently has been made by the government. Now the question becomes, how does the defense want to proceed? And will William Wood want to proceed to a jury trial, or will he want to enter a guilty plea? And that's, I guess, really up to us at this point in terms of discussing that with him and then conveying that
Mm-hmm.
information to the government.
Okay. Well, that's about it. I'll stop the recording.